My time's going to start talking about the Freedom of Information Act, and as I'm going to state different Connecticut general statutes, the term referred to as CGS. CGS 1-200, paragraph 5, definition of public records or files means any recorded data or information relating to the conduct of the public's business prepared, owned, used, received, or retained by the public agency, or to which a public agency is entitled to receive a copy by law or contract under Section 1-218. Whether such data or information be handwritten, typed, tape recorded, printed, photostated, photographed, or recorded by any other method. CGS 1-225, formerly Section 1-21, posting online requirements of minutes and agendas, meetings of government agencies to the public, recording of votes, schedule of agenda or certain meetings to be filed and posted on websites, notice of special meetings, executive sessions. A, the meetings of all public agencies except executive sessions as defined in subdivision 6 of Section 1-200 shall be open to the public. The votes of each member of any such public agency upon any issue before such public agency shall be reduced in writing and made available for public inspection within 48 hours and shall be recorded in the minutes of the session at which taken. Not later than 7 days after the date of the session to which such minutes refer, such minutes shall be available for public inspection and posted on the such public agency internet website if available, except that no public agency of a political subdivision of the state shall be required to post such minutes on the internet website. Each public agency shall make, keep, and maintain a record of the proceedings of its meetings. CGS 1-2-10, formerly Section 119, access to public records, exempt records. A, except as otherwise provided by any federal law or state statute, all records maintained or kept on file by any public agency, whether or not such records are required by any law or by any law, rule, or any rule or regulation, shall be public records, and every person shall have the right to 1. Inspect such records promptly during regular office or business hours. 2. Copy of such records in accordance with subsection G of Section 1-212. Or 3. Receive a copy of such records in accordance with Section 1-212. Any agency, rule, or regulation or part thereof that conflicts with provisions of this subsection or diminishes or curtails in any way the rights granted in this subsection shall be void. Each such agency shall keep and maintain all public records in the custody at the regular office or place of business in an acceptable place, and there is no such office or place of business for the public records pertaining to such agency shall be kept in the office of the clerk of the political subdivision in which such public agency is located, or the Secretary of State, as the case may be. Any certified record hereunder attested to as a true copy by the clerk, chief or deputy of such agency, and such of other person designated or empowered by law so act, shall be competent evidence in any court of this state of the facts contained therein. CGS 1-240, formerly Section 1-21K, any person willfully, knowingly, and with intent to do so, destroys, mutilates, or otherwise disposes of any public record without the approval required under Section 1-18 or unless pursuant to Chapter 47-87(1), or alters any public record, shall be guilty of a Class A misdemeanor, and each such occurrence shall constitute a separate offense. With that, the BAA minutes were submitted on time by our recording secretary. They were not posted by the town until the end of May. Those minutes, after finally being posted extremely late, were then removed, altered, mishandled, or respectfully requested they be amended before adoption by the town manager. Exhibit 3. As most of you are aware, the Board of Assessment Appeals minutes of May 28th, I have exhibits A and B, were removed. While researching our minutes, I found that under the Download tab of the drop-down menu, it brings up a previous version's options. Exhibits 3 and 4, or Exhibit C, the 4 minutes, and Exhibits D and E show that the number of pages for those minutes were changed from 14 pages to 12 pages. Exhibit F shows how the 322 minutes, the 310 minutes were attached. Exhibit G shows the 411 minutes where the 511 minutes were attached. While they may be back to the original status now on the first page under the minutes, minus, of course, the 62 pages of the 528 minutes not being posted, The previous versions show that they were edited, pages were deleted, minutes attached to the wrong dates. These are all violations, as I read them, of the Freedom of Information Act. I respectfully submit all 8 pages of exhibits. Thank you. We scheduled during our March 10th meeting the hearing schedule for the month of April to be on Monday and Wednesdays from 1 p.m. to 6 p.m. and Tuesdays and Thursdays from 4 p.m. to 8 p.m. On March 11th, the board chairman received an email from the assessor's office. It reads, "I'm going to post the meetings, but the town has informed me that no town employee would be able to take minutes during the normal course of the workday. I can come at 5 and continue to schedule the hearings, do the prep work, and transcribe the minutes. This year, we will record all audio of all hearings. This will allow us to be able to transcribe any missing notes. I'm sorry for any inconvenience this may cause." That came from the assistant assessor. The first week of our hearings, there were 3 town employees that included the assessor himself recording the hearings, which started at 1 p.m. on Monday and Wednesdays. I estimate about 30 hours of them sitting in our hearings during the first week alone. The town manager in the last meeting stated the department was overworked and understaffed. The assessor should never have been in the room to begin with, let alone recording the town residents and us. It was, to say the least, contentious because of their failing to abide by the Board of Assessment Appeals handbook on page 26, and the assessor should not be in the room during hearings, and our specific rules and regulations regarding taping of the hearings. Being on this board for the last 9 years, the treatment that I went through and what I heard from the residents who either met with the assessor or had any contact on their property, that kind of aggressive behavior is not how we treat people in Enfield. When I heard the testimony from these people, it was detailed, and though they didn't know what others have testified to, it was very consistent in the treatment, and it revealed a pattern by this assessor. We, too, are lifetime residents in this town, and I find this type of behavior of any type of town employee to be truly unacceptable. I can tell you I have never felt so under siege while trying to do hearings and with recorders, the assessor in the office at the time, and like I said before, having 3 people from the town employees in there recording, and we were told we couldn't have 1 employee to assist us with our hearings until after 5 p.m. So what happened? Why were they all of a sudden all available from 1 p.m. to 6 p.m. all week? There was a lot of stress on the residents and on this board, and I can tell you there was absolutely no reason for it. It was terrible, and something needs to be done, and I thank you for listening to me. I want to talk about Vision Government Solutions. Now, the town has been using Vision as a company to do our revaluations. This company, in my personal and my 20-plus years of real estate experience, is nothing more than a data manipulator. The formulas that were used to adjust our land and our neighborhood assessments, I feel, are not accurate to the real sales data for the town of Enfield. My personal experience with this company of going for a hearing, the experience was, to say the least, not what I thought or what she expected. As I mentioned that my neighbor's house and mine were very similar homes, yet mine was higher than theirs. After a back and forth and a discussion, the response from Vision was, "So do you want me to increase your neighbor's assessment?" I was shocked, to say the least. When I mentioned that, I now understand when people come into the Board of Assessment Appeals that they're mad after their Vision appraisal hearing. She stood up, screamed at me, and said I should have told her that I sat on the Board of Assessment Appeals. She stormed back into the office of the assessor's office, stayed in there for a few minutes. She came back in and told me, "I'm not lowering yours, but if you want, I can increase your neighbor's." I stood up, told her to have a nice day, and left. She was furious and stormed back into the assessor's office. When I left the hearing, there was no change to be made to my field card. It states right on there, hearing, no change. As my street card, and I have the example, shows, there is a slight change made by Vision. My old-style kitchen, it was changed to average. And trust me, today my kitchen is still old-style. They also changed my effective year date. from 1984 to 1989. So it increased my assessment by $2,000 when that was supposed to be a no change. This pattern was repeated often in numerous hearings this spring. When I learned through the reevaluation what Vision did, the town and the Enfield should not be doing business with them. Whatever we're paying them is way too much for the faulty information that they're producing. Please look into and perform an audit on the town's assessor's system and the reevaluation company, Vision Government Solutions. Thank you again. I am done for the evening.